Hi, I'm Darlie Twitty, a litigation attorney with Melone Hatley at our Newport News office. And today we're going to talk about child support in Virginia. A lot of people assume that the non-custodial parent always pays child support, and that's not necessarily the case. And today's video is going to break down how Virginia determines child support calculations and whether it's always the non-custodial parent. A common misconception in Virginia is that the net or take-home pay is what's used to calculate your income. Virginia is a state that actually considers your gross income, and a lot of clients are surprised to find that their military benefits, their BAH or their BAS is included in that, and it actually extends further than that. If you are living rent-free, that's considered an in-kind type of income. So in Virginia, we do consider your gross income before taxes, not your net take-home pay afterwards. So that is a common misconception that a lot of clients have. So coming to talk to an attorney about that can help you figure out your child support calculation correctly. Another thing that is calculated into a child support calculation in Virginia is work-related childcare expenses. So if your child is going to daycare or a before and after school program, because one or more parent is working, then whoever's paying for those childcare expenses, that will be deducted from their income in calculating the child support amount. Another thing that's taken into consideration is who is paying for the child's health insurance premiums. And there are specific formulas about how you figure out specifically that child's health insurance premium, because it's probably not the full number that that parent's paying, but that's another thing that's taken into consideration. Another thing that Virginia courts recognize is if the child or children who are the subject of one child support dispute are not the only children in that family. One parent might have another child that they're paying or receiving child support for, and that will alter that parent's income, either up for receiving that income or down if they're having to pay for that child support. So there's a lot of different considerations that go into what counts as your gross income. And that's why you should come and talk to an attorney about how to calculate that. Even attorneys in the same case and the court often will have different calculations when they put all those numbers together. So the concept of child support in Virginia comes from the idea that a single household with both parents may have dual incomes. So you're going to consider both parents' incomes. I like to think of it like there's this bucket of income. And so all of the income that's coming into the wage earners in that household goes into that bucket. And then the Virginia courts presume that a certain percentage of that income is going to support the child or children. So when those spouses or parents separate and are no longer in one bucket of money and they're in two, three, however many, we still want to take that same amount that was supposed to go towards the children and make sure that that amount of money is supporting the children. The guidelines presume that the primary physical custodian is paying their share of child support in their everyday lives. So by paying the electric bill, by paying for school supplies and new clothes, their share is already being spent directly on those children. So they don't necessarily have to make a payment to the other parent. However, if there is a parent who doesn't have as much parenting time with the children, then you can see how their money isn't necessarily going straight towards supporting that child. That's where the child support payment comes in. The non-custodial parent may be making a payment to the primary physical custodian, and that allows that primary physical custodian to spend that full amount on those children. It's not paying the parent, it's supporting the child and making sure that the child or children have that full amount that the court presumes would have been going to support them had the parties still been in one household, that they still have that full amount. It doesn't mean that a parent who's not the primary physical custodian doesn't ever pay for things when they have the children with them. It just means this is the best way that the courts and the law has found to make sure that the children are supported. And that's what we're always trying to do, is put those kids first and make sure that they're not suffering just because the parents are no longer together in one household. Another consideration that comes up is, what about unreimbursed medical expenses? So you've got things like braces and glasses and other things that come up where maybe your health insurance doesn't cover it, and it's not school supplies or it's not in the regular things that you're using that child support money to pay for, that can be part of a child support order. And usually the percentage that each parent would pay towards those unreimbursed medical expenses is the same kind of pro rata share as their percentage of incomes. So if you've got mom who's bringing in 75% of the income and dad's bringing in 25% of the income when you do the child support calculation, then when it comes to braces, mom would be paying 75% and dad would be paying 25%. So that way you want to make sure that it's in proportion to what your incomes are. Sometimes people forget and will write into an agreement that you'll split those costs 50-50. But if the income that you're bringing in is not 50-50, then that ends up being kind of disproportionate. So you want to take that into consideration and make sure that you make unreimbursed medical expenses in the same proportion to what the parties' incomes are. So right off the bat, it's not automatic that the non-custodial parent is going to be paying child support. If you have the exact same number of days with the children, if you've got a schedule where it's week on, week off, or it's 182 and a half days with one parent and 182 and a half days with the other parent, and your incomes are exactly the same or pretty comparable, there probably won't be a child support payment made from one party to the other. And really, there's no primary custodial parent and non-custodial parent there. You are truly sharing custody equally. So there might not be a child support payment. When you move one of those factors, that's when there's probably going to be a child support payment. So if both parties make the same amount, but one party has a lot more time with the child, then the party who doesn't have as much time is going to end up paying to the other parent. If both parties have the exact same time, but one party has a lot higher income, then that party's probably going to be paying to the other parent. So there are these different factors at play, and everybody's situation is going to be different, which is why you really need to come talk to an attorney. Make sure that you're considering all of the income that you can. Make sure you're getting credit for all of your days. Virginia defines days very specifically. It's not the layperson's definition of a day. So come talk to an attorney and we can help you make sure you're getting exactly what you're owed, or make sure you're paying exactly what you should be paying and not any more or not any less. In Virginia, there are actually two different formulas that are used. You might hear lawyers or other people talk about a shared custody formula or a sole custody formula. And sometimes clients are taken aback because one party doesn't have sole custody, but we're using a sole custody guideline. So in Virginia, there's this tipping point. If the primary physical custodian has the child 75% of the year and the non-custodial parent has the child 90 days or less, then the guideline that's used, the formula that's used, is called a sole custody guideline. It just does the calculation a little bit differently than the shared custody guideline that's used when the non-custodial parent has 91 days a year or more. Then every single day that the parents have with the child, it's going to tip the scales a little bit differently. Sometimes the sole custody guideline spits out a formula that's actually less money than the shared guideline. So you want to run both formulas and see what's best. And, both parties are probably going to have differing opinions, but you work it out or the court decides. But that's the difference in those two formulas. It doesn't mean that one party has sole custody of the child. It's just a different formula that's used. Another common misconception is waiving child support. So you can't waive child support in Virginia. It's not yours to waive. That money is going to support the children. You can waive spousal support, but child support cannot be waived by the parents. What you can do, and where this may be coming from, is you can deviate from the guidelines. The guidelines and the calculation that is set up in the Virginia Code, in the statute, is the presumptive amount that would be going to support those children. But you can overcome presumptions, and there is a whole statute with a list of factors that give reasons why you might deviate from the guidelines. And one of them is you agree to deviate. So if you and the child's other parent agree that one or the other is going to pay more or less than what the guidelines say the presumptive child support amount is, that's okay. You're not waiving child support. You're deviating from the guidelines. And as long as you're doing so in the best interest of the children, then the court will usually be on board with that. You put some numbers into a worksheet. There are calculators online. I could do this myself. And I would strongly caution you against that. Even with attorneys on both sides and the court, a lot of times we all come to court and we all have different numbers. The reason is there are usually disputes over what does count as a person's gross income. Do we include that bonus? Do we include the PPP loan that only happened one time? Yes. Do we count how much you're spending on daycare and how much I'm spending on daycare? What if I could be watching the kid instead of the kid going to daycare? So different people will kind of mold these guidelines worksheets to be what they think is fair, but also what helps their client. And so the court will be there to say, okay, yes, we include that. No, we don't include that. Or maybe I've seen it happen before where, fine, if you both want to pay separately for two different health insurances, then go ahead and you'll both get credit for them. So you need an attorney to help you out because it's not as simple as it seems. It should be straightforward, but there are just a lot of factors that go into it. And you want someone who knows all those nuances and who can tweak things in your benefit and knows how to defend those arguments with the court. So if you or someone you know is trying to figure out child support and realize that you need a partner on your side, contact a lawyer at Melone Hatley. We're your partner in divorce and estate planning.